Good afternoon, and welcome to today's AAA's Clause Builder, a proactive tool for drafting ADR clauses and contracts, informational program sponsored by the Alternative Dispute Resolution Committee of the Entertainment Arts and Sports Law section of the New York State Bar Association. Feel free to use the Q&A box in the Zoom portal if you would like to pose a question to the speakers. Please do not use the chat box to submit questions to faculty members. At this time, I'd like to pass the floor over to our moderator for today, Kyle Beth Hilfer, co-chair of EASL's Alternative Dispute Resolution Committee. Kyle Beth?
Hello, everybody, and thank you for joining us for what's going to be a very lovely informational program for you. Today, we're going to explore a significant tool for dispute resolution and transactional attorneys who are drafting dispute resolution clauses, and that's the American Arbitration Association's Clause Builder tool. We all hope that our clients do not end up in a dispute, and certainly at the outset, they only intend good results. They enter into contracts with optimism, focusing on collaboration and success. But a prudent legal strategy demands that we anticipate potential conflicts before they emerge. As we all know, the best laid plans can certainly go wrong. Our job as transactional attorneys is to protect our clients with well-crafted contracts and a dispute resolution clause that, as best as possible, anticipates the nature of any disputes and provides instructions to future litigators, the clients themselves, and the dispute resolution provider about how to conduct any dispute resolution in the future. The Clause Builder tool empowers legal professionals and their clients to design proactively robust dispute resolution mechanisms. And in the process, it helps to minimize litigation costs down the road and preserve business relationships. Today, we will focus on this tool's capacities, its adaptability for complex contractual landscapes, how the AAA has enhanced the tool with artificial intelligence for precision drafting, as well as practical implementation strategies for legal practitioners. Today, I'm joined by Mansi Karol, Director of ADR Services within the Commercial Division at the American Arbitration Association's New York offices. And so I'm excited to have this conversation with you, Mansi, and present the Clause Builder tool. I know that I am a longtime user of Clause Builder. For years and years, it's always bookmarked, and when I'm drafting a contract, I go to it. And we've made significant enhancements now. Full disclosure, I am a AAA arbitrator and mediator. However, I was not part of the project in any way that updated the AAA Clause Builder tool. So I'm excited to hear about this as well, but I do have that connection. You will find in the chat my email address if you have questions, and also Mansi will post some links that come from the AAA that will just have helpful resources to you. There will be a recording of this program that will be pushed out to you through the New York State Bar in case you want to listen again or follow up in any way. So with that, let's get started. So Mansi, what can you tell us about the history of Clause Builder?
Sure. Firstly, I want to thank you, Calbeth, for coming up with this idea, and to Sherman, who arranged this webinar for us. It's always a pleasure to work with both of you, but I don't want to take too much time. So let's deep dive into history of Clause Builder. So over the past 15-20 years, what AAA was going through was a lot of redundant clauses. And then in 2015, we had a committee and we came up with this idea that we should have a resource for users and public in general tapped into our website, adr.org, because we believe that a well-written dispute resolution clause is the foundation for an effective dispute resolution process. So we came up with clausebuilder.com. And if you just go to our website, you'll see Clause Builder, which just helps you draft a good clause. And when I say a good clause, everyone, when two transactional attorneys are working on contracts, everyone believes that at that point of time, they're getting into a contract and the clause is fine. And not many attorneys pay attention to actually arbitration clause and what should be included and what should not be included. I do believe, some of us are from ADR backgrounds, but not many of us are from those backgrounds. So basic components in a clause such as the hearing cycles, the number of arbitrators, the expertise, should there be mediation, is really not included in a clause. And when, actually there's a break in marriage and there's a arbitration filed with us or any other provider, parties actually have to go to court just to figure out what's the hearing status or what rules should be applied. So that's why in 2015 we came up with this resource specifically, because we thought that it will be a good resource and it's free of cost. It would be a good resource for everyone in general to make sure that when they incorporate a clause in their contract, it covers all the key components. So this is the history of Clause Builder, and over years, this resource has been enhanced with step mediation clauses, governing law. Should there be discovery? Should it be a documents only case? Should there be a confidentiality aspect involved in the clause? Should we plug in that? Should appeal be allowed or not be allowed? Because generally what everyone thinks is there's no appeal in arbitration, but if you incorporate that in a clause, appeal is an option. It's not very common, but we do see some clauses that have it, and AAA does have appellate process too for that. So that's a little bit about Clause Builder.
Yeah, so it's interesting because when I'm wearing my transactional attorney hat, I'm usually negotiating on the other side with another transactional attorney who usually is not an arbitrator. I think I'm unusual in that I wear both hats, and bring some of those lessons back into my transactional practice. But I've seen over and over clauses presented that maybe don't fully understand the arbitration process or how tailored it can actually be for the benefits of the parties. So if you're looking at a clause that you've seen over the years, what might you see in a clause that's missing or in a poorly drafted clause? I have some of my own ideas on that, but I'm curious what you've seen from the AAA.
Sure. So, like I mentioned, lots of times, I mean, firstly, even now, it's 2025. Sometimes we get cases where arbitration clauses are actually drafted in the 90s or, early 2000s. So it's not uncommon to have clauses from even 20, 30 years ago. And what we notice is sometimes, it's just a very basic arbitration clause that in case of a dispute, the case would be resolved by American Arbitration Association's commercial rules. And that's it. Sometimes they do mention number of arbitrators and the hearing citers, or, if there's a step mediation. For instance, there was a clause from 1961 that my colleague Jeff and I dealt with a big case. And so when we go back to history, we do see that major aspects which I just mentioned, such as what rules should be applied, locale is a big one, are missing. And that's why in 2015, we specifically came with a basic model of a clause where everyone can actually incorporate at least what should be included in a clause. We do see very often the locale is missing and parties are fighting over whether, there are two parties located in different parts of United States, and whether the arbitration should be in California or should it be New York, then which is important because it comes to the next steps, whether the arbitrators should be from New York or whether they should be from California or could be any other region. I'm just giving an example. So these are just certain aspects that we see missing in a clause, and then court has to provide clarifications. So that's why, and it's not uncommon to see that. So I think these are the basic things that we see in a poorly drafted clause. I would like to highlight two things. Firstly, it's the locale, which is basically a hearing citers. And secondly, at times the rules are missing. So you again have to go to court for that.
Yeah, so I sort of there are two ends of the spectrum. The poorly drafted clause would either be too broad or too specific. So sometimes as an arbitrator, or I'm sure you've seen this in AAA, you'll see clauses that so micromanage the process to a point of being overkill and not giving the process
Yeah.
needs to breathe. So in some ways, these are the big issues that a tool like Clause Builder can help transactional attorneys think through ahead of time, and also understand the full range of issues that you might see. And I agree that 30 years ago, people were maybe a little more loose with these clauses. And of course, we're still litigating those cases now as conflicts arise. But to understand that you might want to include something on confidentiality for this particular transaction, even though for another transaction it may not be necessary. So with
Yeah.
that, what types of ADR clauses can Clause Builder help to draft, and how does that tool guide users through the process of building an ADR clause?
Definitely. So like you mentioned, firstly, it's very important to tailor the clause per the needs of a contract. And depending on what kind of a case is it, how many parties are involved, um, it is extremely important as a transactional attorney to make sure all important aspects based on the kind of contract are included. Now, talking about what kind of ADR clauses Clause Builder can help with, we help with commercial US domestic clauses, construction, international, healthcare, employment, and labor. So you could draft any of these clauses on ADR.com. When you go to Clause Builder, you can just tailor the clause per your needs. You don't even have to use AAA as a provider, even if you want to go for an ad hoc arbitration, or you want to use some other providers, because sometimes parties do want to use in a very local region, they do want to use a local provider, or you can do that. What we came up with is that there should be a resource for public in general, which can walk you through a clause and what should be included and what should not be included. For example, we would not encourage uh, lots of things to be included in clause. Discovery is one thing that we discourage. Yes, in a very big case, you can include discovery if you would like, but there has to be limited discovery, and the arbitrator would walk you through the process if the arbitration is filed. But again, it depends on the nature of the case. Confidentiality is a new point that has been added. And we don't have stats on it, but it's a good add to the clause if you want the arbitration to be confidential right in the beginning of the case. And if you see that in a clause, we can actually incorporate confidentiality right in the beginning. So at AAA, when a high claim case is filed, we basically do an administrative call with both sides and go through all important aspects of a clause. And hence we came up with Clause Builder as well, because we noticed that lots of things were missing when we were talking to both sides, and public and house counsel in general needed a resource. So as I already mentioned, Clause Builder can help build any kind of clause and walk you through the process. You can use the clause or you cannot. It's up to you.
So I'm going to invite the audience, if you want to help us out with this, if you can, as many of you who'd like, please post one word in the chat that describes a problem you faced, something you've had to scratch your head about when you are drafting an ADR clause. Maybe we can just wait 1 second and see if people chime in. I hope you'll all participate. If you're trying, I'll give you some prompts. If you're not sure what to put, it could be confidentiality, it could be discovery, it could be how many arbitrators, it could be what kind of dispute resolution. Am I looking at mediation, arbitration, some kind of hybrid parallel path? Just give us some ideas for anybody who's out there listening, so we know you're there. Please add some thoughts to the chat. We'll give it a second and see if anything comes in. And while we're waiting for those to come in, and I'm seeing some coming into the question and answer, so they're not necessarily visible to the audience, but I will read them out loud if they're not in the chat. While I'm waiting for those answers to come in, this would be a time where I'm going to ask Mansi to start to share her screen so we can get a sense after I read off these answers how Clause Builder has been modernized with artificial intelligence. So while I'm waiting for Mansi to do that, let's see some of the things that people have posted. Timeliness, like when do you, I think you probably mean what time period for running the dispute resolution process or when to initiate it. Attorney's fees to the prevailing party, choice of law. These are definitely issues that Clause Builder can anticipate clauses and help you to give you options for how to draft, and as well as a whole potpourri of other ones. And I think we're going to see with the demonstration that's about to start sharing screen right now, we're going to see how Clause Builder can work with this way for some of those issues. A few others have come in: applicability of rules and procedures, cost, discovery. Apparently, Sharman, the chat is disabled, so thank you everybody for participating in the Q&A, and I'll be monitoring that in case anything else comes in. So those are some examples, and all of those are great ones that we'll see how Clause Builder can help us. So with that, you should be able to see on your screen what Clause Builder actually looks like today in its modernized version. And I'll turn it back to Mansi to show us how it works and how AI has been incorporated. And I think we lost, right now we're just on your desktop, we've lost Clause Builder.
Oh, I'm so sorry about it. All right, so is everyone with me?
Yeah.
So before I show you the so this is what Clause Builder looks like. So this is the Clause Builder which came up with in 2015, where you can actually choose the type of clause, and you can just build a clause. Now, when I go to the AI Clause Builder, this is what pops up. So what you do is you click add a new clause, arbitration. You go to draft an arbitration clause.
And that's a sample prompt. You can
this is
change
a sample.
that prompt to anything
Definitely.
you want. It could be draft a commercial.
You could do draft a commercial, construction, employment, whatever you want. You can also type it. You can include a step mediation. So now when you go under the arbitration clause options, these are all the things that under AI we are trying to include in a potential clause. And we would do arbitration and draft commercial clause, and then AI would generate a clause. So it will just take a minute. And
I just want to interject there. If you start with that very broad prompt, you're usually going to get the most sort of vanilla, broadest,
exactly,
really not very specific clause, but just sort of, and that might be all you need for a very simple commercial relationship. But then when you go to the left, you see all these options of things that you can add into those that clause to make it.
So you can add all these things and then ask them to prompt to make a clause, to come up with a clause again, which would include all the important things that you mentioned that we would want to with these headings. And then you know what, you can also email this clause to yourself. So
one question,
email will be sent to you. Yes.
I think, and I want to just clarify for the audience in terms of use of artificial intelligence, I don't think this is a generative AI tool in the sense that you can sort of just have discourse with it. Like am I correct that you can't say to it, tell me why or why not I should include a confidentiality clause in this case?
That is absolutely correct. So as of now, this is Clause Builder Beta, and we are still working on, improving this resource. So what Clause Builder originally did is that you would have to choose commercial clause, the number of arbitrators, you would have to include yourself, you would have to include different aspects yourself, and then you would be walked through different aspects and a clause would be created. But in AI beta clause, you just click a commercial clause and a few options, and then a clause is emailed to you, and then it's up to you how you want to edit it or not.
Right.
But it's just a resource to make it faster,
Can
so you don't have
you
to
share
spend a lot of time.
Can you share that one more time? Right now, we're looking at your desktop. I just want to give people a quick look. If we can just scroll through the options on the left, sort of slowly,
So
so that everyone can see. We have governing law, discovery. Do you need something special about e-discovery? Do you want to have a documents only hearing rather than a live hearing? What remedies do you want the arbitrator? How do you want to limit or free up the arbitrator? There'll be different clauses that'll show you some options. Is it going to be a reasoned opinion or a standard opinion, et cetera, et cetera? And you can see all the different options. Generally, when I'm drafting, I don't include every single option in a
exactly,
transaction.
and you don't have to. It's these options are just for you to, just to explore, basically.
Exactly. So you can see the sort of robust possibilities, and then you can decide what do you need for a particular transaction. So how has the tool been kept up to date with I don't know if you want to stop sharing your screen now.
Yeah, so now I'll stop sharing my screen,
Okay.
but I actually posted 2 links here. So this is a very new tool. It was just launched last year in June 2024. So that's why it's in its beta stage. So we are hoping to, make it better as users use it. In Legal Week, this tool was introduced, and we've got positive feedback from many clients, specifically, small businesses. It's very effective for lawyers who are incorporating clients in small businesses, because when it comes to a multi-dollar or a multi-billion-dollar contract, there are many more things that have to be incorporated. But something where, it's a general contract between two parties, this tool is really intuitive and easy for anyone to just review and include a contract, and they don't need to actually go to and fro and waste too much time. But as I said, this tool is still new, and so there's also a feedback button to get feedback from users to see how is it going when you use Clause Builder AI.
That's great. So what about on the
We are working on enhancing it. That's what I mean to say. Sorry, I didn't mean to cut you.
I'm sure it will only become more robust, right? So how is Clause Builder working with international cases that may be governed by different jurisdictions' laws?
So when it comes to international cases and different jurisdictions, as I said, it's a resource. So it doesn't matter if it's an AI tool, and parties don't have to use AAA ICDR. So our international component is ICDR, International Center of Dispute Resolution. They can actually incorporate components from Clause Builder or Clause Builder AI into their contract. So it's just to make sure everything that should be included in a clause is there. So it can be used internationally or domestically. It's to build a clause which incorporates everything.
So at least they have that option of knowing that it can be a resource on something with
Exactly.
as well.
Exactly, because AAA is a not-for-profit, so our goal is more to spread awareness, and that's why it's a free resource. You don't have to pay anything to use this resource, so which is great because You don't have to, really incorporate what, this AI clause builder or clause builder is asking you to do, but it's just good to, just bookmark whatever you think should be included in your clause.
I will note on that when you go to Clause Builder to use it, you will be asked to put in your email address and accept some terms and conditions of use. So if you have some concerns about that, of course, read the terms of use. I say that as an
Definitely.
advertising lawyer. Most people don't read the terms of use, but I suggest you do. And you will be asked to, you're not asked to pay any money, but you will be asked to give your email address. I have no idea what the AAA does with that, but
So basically it's to email the the clause to you. So
I
then,
see. Okay.
so when you fill in your email address, once the clause is built, you get the clause in your inbox if you want to just send it over. So it's just convenient rather than copying and pasting it. And of course, it's good to, know how many users are using it. So we can work on it accordingly to get better feedback and tailor it better for the next set of users.
So a couple of questions that have come in the chat. Someone has asked, is this tool specifically for ADR clauses, or are there similar related tools for other clauses in the contract? This is a specific ADR clause. As to whether there are other tools that wouldn't be through the American Arbitration Association, that's particularly focused on the dispute resolution aspect of it. And as to where to access the tool, I believe the links yes, the links are in the chat that you can, and if for some reason you can't find it, if you lose that link, just
You can
Google.
always type clause builder AI and you'll
Yeah.
AAA clause builder AI, but I also plugged in the link right now.
Yeah.
For clause builder AI, let me just plug in the link for clause builder itself too. So, you have both links to walk through. So this is clause builder. I just did clause builder AI and now I'm pasting clause builder. So you can also compare and contrast because not everybody would be very, it depends on what kind of a contract it is. For some contracts, I think clause builder tool is better. You don't really need AI if it's a very basic contract. But for others, AI might be the go-to thing.
Yeah, so you certainly could play around with the 2015 version, which was enhanced over the years, but not without the AI. And if you get lost and can't find your way, you can always just Google clause builder, AAA, you'll find it. If you're looking for the AI version of it, the newer version, of course, just include that in your search.
And if you also go to our website and go, just type, there's a tab clauses, and under that, all this information is there. So
Yeah.
there's no way you can get lost.
So what mistakes do users make when using the tool, whether the older version or the enhanced version? Could you name maybe 2 or 3 top mistakes that you see people making?
Yes. So as I mentioned, it's extremely important to tailor the clause per the contract and per your needs. So what we see is that sometimes, users include too many things in a contract. What I mean is a clause, arbitration clause, and sometimes they tend to miss on an important thing like, say, the expertise in an arbitrator, which we believe that should be included in a high claim specific dollar case. So definitely, think about what are you getting into, what kind of a contract it is. Talk to your opposing counsel to see, and both sides should be on the same page, because very often, when we walk through the clause in our administrative call, parties disagree. Oh, I didn't agree to one arbitrator, but then we say that it's in the contract. We see one arbitrator here, and per our AAA commercial rules, the contract overrides the rules. So if there's something in a clause, we would go by that. Only if, say, division of costs is not mentioned in a clause, which is usually not, we would follow the rules where we split the cost 50-50 between the parties. Oftentimes, we don't see arbitrator expertise. I would not say it's really important to include them. But yeah, if it's something important or specific you're looking into, why not include that? But at the same point of time, I just want to highlight, we did come across arbitration clause where there were two cosmetic companies involved, and they wanted the CEO of one of the company, or it was a board member, to be the arbitrator. And please don't do things like that, because it is extremely difficult for even institutions like AAA to administer such arbitrations, because people like this don't know what to do. They can't sit as chairs. They don't have the expertise. And it was hard to recruit, panelists for cases like this. So we often tell parties that when you're incorporating a clause, make sure it's doable just in case there's a default. And we often also review clauses, not from attorney perspective. We don't give legal advice, but if there's a transactional attorney and he or she tells us that, can you just take a look and what rules should be used, we do let them know that what kind of rules could be used in a specific case.
Yeah, and I'll just add a few things there. If you're dealing with a consumer arbitration where it's a corporation that's, whether it's a sweepstakes or a loyalty program or terms and conditions for your website or things that consumers are accessing a contract with the corporation, you'll probably be governed by the consumer rules in the AAA, assuming it's personal services or for household use. And in that case, there is actually a very robust library online that you can look at that shows you how many big name corporations have drafted their consumer dispute resolution clause. That's particular to the consumer world, and there are some really significant nuances to drafting a consumer arbitration clause that do not apply to general commercial cases. So you won't find some of the issues there might seem a little odd to you if you're just drafting a general commercial case. And if anyone has questions about that, I'm happy to discuss that with them. And I'm sure the AAA is as well. But that's just another resource. And I think the takeaway from what Mansi is saying as far as mistakes is don't under lawyer and don't over lawyer, right?
Definitely. Agree.
Yeah, it's often in the transactional world, though, this is the clause that gets the least amount of attention. I probably spend a lot more time on it because of my background. If you're dealing directly with a client and there's no GC intervening between you and the client may be overwhelmed by all the options, and you're just going to have to make the best choices for your client, and they're really going to rely on you to just tell them what to do. And you might sort of smell out their willingness to, things like, do you want a single arbitrator or three arbitrators? They might have an opinion about that, but they're not going to necessarily have an opinion about all the options that Clause Builder offers. So you're going to have to use your best judgment and maybe speak to some arbitrators if you don't have a lot of experience in this area, so you can understand, why is Clause Builder even offering me some of these things? You may not know. And that really could be a subject of another whole program where we go through each of the options and explain the mistakes that are associated with each of the options. We don't have time for that today. You'll often find that opposing counsel may have the same limited exposure to arbitration clauses, or I prefer to say dispute resolution because there's also mediation options. So you may have to do some education of the other side as you work through. And Clause Builder is a great way to show that, to do that education, because it's kind of laid out for you. And with that, I'm going to ask, that's my transition to my next question for Mansi, is how can we use Clause Builder as attorneys to demonstrate the value of ADR to overcome client or opposing counsel concerns about the use of ADR?
Yeah, thank you. And that's a very good question. So as Kalbit, you mentioned that, when you are in that transactional phase, you don't really think about all these aspects. What if there's a dispute, or will there be a dispute? Because obviously when you are, helping your client draft a transactional contract, they really don't think about a potential dispute that may happen between the two parties, because everything is going well and you want to get into that agreement. But like I mentioned in the beginning, that a well-written dispute resolution clause is the foundation for any effective dispute resolution process. And when it comes to clause builder for in-house transactional attorneys, they can actually show this free resource to their clients to incorporate all important aspects just in case there's a dispute. We didn't talk about mediation a lot, but at AAA, even though we call ourselves American Arbitration Association, we do encourage mediation a lot, and we do have a step mediation clause option when it comes to building a clause. So that's another important ADR process that you can actually incorporate in your dispute resolution clause, which is effective and it can save you a lot of money. There are also studies. I wouldn't say it's based on clause builder, but where arbitration or ADR processes, arbitration versus a court process, where arbitration is way more cheaper than going to court. So given that, I think it's a good resource for transactional attorneys to incorporate for a potential arbitration clause in a contract, but also to encourage ADR processes like mediation, arbitration, just in case there's a dispute. It's faster, it's more economical, and you can continue a good business relationship, because lots of times there's negotiation and some of 65% of arbitration settle just because of that. And our arbitrators actually help with the settlement too. Uh, so you can also have an ongoing business relationship. So I would say it's a better resolution than going to court. And this resource can help you build a good clause to save time and money.
Yeah, and I think it sort of serves as a checklist. That's the way I tended to use it over the years.
Agreed.
It's as what do I need to think about, as a checklist of what might be appropriate for this particular set of parties, and the unique relationship that they have, what might happen in the future. So it kind of helps you forecast where things might go wrong and how you can proactively deal with that. And I think from in my practice, one of the key benefits of using that versus drafting a clause manually is I've got that checklist right there. Sure, it saves me time also because it gives me sample clauses that I can select from, and these like any kind of template, it's nice to have that work done for you. But I see that as the key benefit of using Clause Builder as a transactional attorney, is to have that checklist and to be able to explain easily to your client. And now you've got this great visual demo with the AI added in of why this is important and why they should be thinking about it down the road. What do you think, Mansi? What do you see as the key benefit of using a tool, this tool versus manual drafting that we've done historically?
Yeah, I do believe that, these tools are really, really efficient, and they are helping not only transactional attorneys, but all ADR stakeholders in general, because we often, at AAA, we often go speak to attorneys too, in-house counsel and even law firms, any size law firms. And what we gathered over the years is that attorneys, they are aware about this tool, and especially I won't name the law firms, but like really big law firms, attorneys have told us that, this is such a good resource, it's free of cost. And when we talk to, our Fortune 500 clients, it's so effective because we can actually show them there's a resource to show live. Clause Builder is a great resource to show their clients live, and with the AI component, it's quick, so they can just, show them, see, these things have to be included in the clause. And most recently, Jeff and me, we didn't realize that, transaction attorneys and big law firms actually use this resource. And they're like, it's a great checklist. We always open clausebuilder.com while we are incorporating arbitration clause for our clients. So even if our clients don't want to see it, we ourselves go through it, and so we don't miss out anything. And oftentimes, when you draft clauses manually, you can miss out an important aspect like, say, number of arbitrators. You say that there will be arbitrator, and then, 1 versus 3, it's a very big question mark. So something so basic can be missed when it is a manual clause, but if you go through this checklist, it will definitely help you incorporate everything in your clause. And over the years, we have been seeing better clauses ourselves too, especially when it comes to high claim cases. I've been handling cases over 10 million, where the claim is over 10 million. And when I see clauses, it's actually easy for us to do the administrative call too, because parties are already fine with what's written in the arbitration clause, including the appointment of arbitrators, because at times both sides want to appoint their own arbitrator and them to select the chair, but at other times they want to follow the rules. So it's really good if it's already incorporated in the clause versus them, fighting when actually a dispute arises over things like this.
And I think on the opposite side, if it's not projected out to be a really high value, large, complex case, still going through this checklist is a good idea, even if it's to say, I don't want to include anything on that point. I want to just let the rules govern and let the arbitrator have the discretion to do what they're allowed to do under the rules, which is considerable. That's a valid choice. And in many cases, that's the better choice to make. So you do have to have your own kind of analytic thinking on, and like any other tool, use it respectfully and with your own engagement and your own thought process involved. And it's best used by people who really understand arbitration and understand the mechanics of running an arbitration. So to your point, Monsi, if somebody says that they want, so-and-so they want an arbitrator from a trade organization, they want that expertise. Well, that person doesn't know anything necessarily about how mechanically to run an arbitration. Might be a nice person to have on a panel, if it's a 3-person panel, but if it's a single arbitrator, it's great that they understand the industry, but they have to also understand how to run the arbitration. And in many cases, I have seen clauses where the expertise is a little over-lawyered or over-suggested. And in fact, you really just have a basic commercial dispute in front of you, and you'd be better served by a really solid arbitrator who maybe you have to explain some language to in terms of the jargon of the industry, or if you go a little broader and say a commercial arbitrator who understands arbitration and understands data analytics or something like that, right? Like that's broad enough that the AAA has the discretion to find you somebody who can do both. So maybe you don't have to spend time educating that person about your industry, but you also have a solid arbitrator, which is ultimately the most important thing for cost efficiency and to get you an award that makes sense, understanding the options that are available to the arbitrator. You don't want to over limit their discretion on injunctive relief, or if you're in doubt about whether to use a clause from Clause Builder, I would suggest that you also pull out the AAA's commercial rules, or whatever rules you're governed by, the construction contract, labor, whatever it is, and see what do the rules say about this. What discretion does the arbitrator have? Maybe that's sufficient. Maybe I don't need to go further as Clause Builder is offering me this. Or maybe I feel uncomfortable with the discretion that the rules have, and so I do want to tailor that. So I always recommend using Clause Builder in conjunction with the governing rules. All of this may take a little more time than you're used to in drafting an arbitration clause or a dispute resolution clause, but it's well worth it in the end to help save the client a lot of money on the other side. I want to ask you, Monsi, what are do you have any analytics to compare clause builder results with ADR clauses that show up in the AAA's caseload? Are you able to isolate those and see how they do?
So as of now, we don't have any analytics because, as I mentioned, it's a free resource. We sort of know who are the users for this resource because we have their email addresses, but we really can't say if they really used us or used clause builder to incorporate a clause in their contract. It's more of a database to know how much, this resource is being used and how should we improve it and how can we make it better. So we do not have analytics, but over the years, we can definitely say that it's being used more because we ourselves are seeing better clauses. So in terms of where, there's not a dispute about ABC and the arbitrations are run more smoothly. And I agree 100% with you. It's extremely important to make sure this is just a tool or a resource for you to build a clause, but at the same point of time, you have to see what kind of rules will administer the arbitration. And then ultimately, how would you save money for your client? So what kind of an arbitrator should be appointed on the case? And what we at AAA, beyond Clause Builder, we also have several other resources, like we have a streamline process. We introduce clients to arbitrators, not all arbitrators, say 5 selected arbitrators, and they can potentially do an interview. And they can interview the arbitrators to see if the arbitrator is a good fit for the case or not. So I would say that Clause Builder is a resource to be used, and we are sharing it as much as possible, but I would not say rely on it. And when you actually look at the little terms, we do have a disclaimer that we are not attorneys, or we are not, have this clause reviewed by your attorney if you're incorporating the clause in your contract.
And I believe the AAA has broad analytics on some of the issues that Clause Builder presents. They may not be Clause Builder analytics specifically, but I'm sure you have analytics on how many cases use a single arbitrator versus 3 arbitrators. You probably have analytics on how many cases give injunctive relief or don't have injunctive relief. There are other analytics available that might allow an advocate, an attorney to back into, well, should I think about this for my use of Clause Builder, and do I want to pursue that issue in my ADR clause? I can't point you to specific analytics on the website, Monty, you can, but
we don't have specific analytics, but as I mentioned, over years, like even our commercial rules, and I'm talking about commercial rules because I work within the commercial division, they are updated. And most recently, when they were updated in September 2022, after 7 years, the number of arbitrators would not default to 3 if the claim is under 3 million. So before that, if a claim was under 1 million, we would default to 1 arbitrator, but if it's over 1 million, we would default to 3. Now the threshold has been increased to 3 million because looking at things, we realize that a $2 million case where the claim is just 2 million, you really don't need 3 arbitrators because that can get very expensive for clients. So yeah, things like this do help us, make our rules more productive for potential users. So when you're obviously incorporating number of arbitrators and it's a 2.5 million contract, you don't need to default it to, or let me say it that way, you would only default it to 3 if you really want 3 arbitrators. Otherwise, the rules would already, mention that. And if both sides are not in consensus, you don't need to really mention the number. We always say mention the number, but rules can really help you, and rules also in updating the rules over years, clauses have helped us to review our internal committees. Even, a very basic thing as partial final award. It was not very popular in the past few years. But now every high claim case has a partial, like not every, but 1 in 5 cases or 2 in 5 cases have a partial final award. So we are actually thinking about if we want to incorporate a rule on that.
Interesting. Yeah. So, and for those listeners who maybe aren't as familiar with what the partial final award is, that's where the arbitrator or the panel of arbitrators, depending on who it is, issues an award that essentially covers the certain very foundational issues of who got it right, who got it wrong, who's liable, what are the damages. But maybe the attorney's fees haven't been included in the PFA because that's another whole exercise to figure that out. So, for certain very complex, long involved cases, it might make sense to do the attorney's fees subsequently in another little mini hearing rather than have both sides go figure out their attorney's fees. Let's see if attorney's fees are even awarded before we go to that trouble. And I also want to point out for the transactional attorneys listening, whatever clause you come up with, whatever clause you draft and gets incorporated into the contract, that represents the meeting of the minds of the parties at that moment. But if it's 5 years later or 10 years later or 1 year later or whatever it is and the dispute arises, the parties are always free to change that agreement. So if you sort of over-lawyered your clause maybe and put in you want 3 lawyers and you have to do the arbitration within 3 weeks, which would be completely ridiculous. And you want some arcane governing law to take place, or I don't know, whatever, you can use your imagination and take it to the worst case scenario of over lawyering. The parties and their new litigation counsel are now sitting there going, what the heck do we do with this clause? Like this is hemming us in. You can always, as parties, renegotiate that clause, or sometimes the AAA will sit down and say, do you really want this? And the litigators will go, no, we really, some guy in the transactional department wrote this and now I'm stuck with it. And they maybe go back to their clients and they get some agreements to change things. So it is the final word, whatever you put into the contract for the moment, but you're always free to change that upon the agreement of the parties. And I've seen cases, where the parties have asked for something and then the case lands on my desk as an arbitrator and I see it's not quite jiving with what's in the contract. So I go to my case manager and I say, what happened here? Are you sure you want me to be the arbitrator? Look what this clause says. And the case manager will say, oh, they ignored that. I've got it in writing agreeing they don't want that anymore.
Yeah, and it's very common to see clauses where, they want to wrap up the arbitration, like a high dollar claim arbitration in 60 days. And per the rules, it takes almost a month to appoint the arbitrators. So how could, like in 30 days, the appointment process is done and the preliminary hearing is done in another 15 days after that.
You can get emergency relief. I should point that out. I mean, we're kind of from Clause Builder, but just know that, if you're worried as you're using Clause Builder and you're worried about time because that the parties may want to continue doing business together and they may just have something they need to resolve, you can always apply for emergency relief. You can always get an emergency arbitrator. So you don't have to hem yourself in with Clause Builder's suggested if you put it in that you want something crafted that says, I only want a 60-day arbitration, it'll give you that. That doesn't mean you should use it.
Yeah, and often, I mean, this is a very important point that, so sometimes if we are asked to sort of review a clause and time frame, we do tell clients that don't include the 60 and 90 days. Usually it takes 6 to 9 months in a big commercial case to wrap up a case. Yeah, include 6 to 9 months because that's doable and that's what the process takes. But don't have windows like 45 days and 60 days. And I'm talking about the high dollar claim cases. When it comes to a mid-sized case or a small claim case, yes, it can be wrapped up in 60 days. So why not? Everything happens in.
Could you define for the audience what you mean by small, mid-size, and high value?
Yeah, definitely. So at AAA, how we divide a small case would be anything under $500,000, where the claim is under $500,000. And the threshold from a mid-sized case would be between 1 and 3 million. And anything above that, we would consider it a, a high claim case. So, but now it could we could also consider 5 million as a mid-sized case, given so many things have changed. But if the claim amount is over 5 million, definitely give you should give a heads up to your clients that 6 months is what it will take to do this arbitration, and not because it's just the process.
And the
It
other,
will take that much time.
sometimes it's not always related to the dollar amount. So particularly in the intellectual property area where I do a lot of my cases, the dollar claim may not seem high value, but there's tremendous relief being sought in terms of injunctive relief or rewriting the parties' relationships and other kind of equitable relief, seizure of goods, whatever might be appropriate in an intellectual property case. And it can despite the claim value being under $1 million in damages, there can be considerable complexity to creating all those equitable relief. So don't be totally fooled by just dollar amounts. You still may need 6 to 9 months or sometimes longer. We aim for 6 to 9 months. But at the same time, if you have a limitation of liability clause in your contract and it's not the type of case that's going to need all that equitable relief, and you see, well, they're limiting the liability in this contract to no more than what's been paid out over the last 3 months, and so it's going to be a lower value case, then maybe you can push the envelope on time a little bit. But I still would caution about being overly restrictive, because a good arbitrator is going to just pick up on that right away and push that case along. And you don't necessarily need to hamstring the future with that clause, because you may find it's also hamstringing your own attorney by doing that. Maybe the litigator has a trial, maybe what the other things that can cause delays. You want to get to the good result. So in the last, we just have 2 minutes left. I just want to talk a little bit about mediation, and not to shortchange mediation by any means, but just to point out that Clause Builder also allows you to build hybrid clauses that either just do mediation, just do arbitration, or do both. And Med-Arb has become a real trend in recent years. Would you agree, Mansi, on that? And
Definitely. So as I mentioned, we also have incorporated mediation in our rules. And usually when I do an administrative call, even if I don't see mediation in the clause, I would talk to parties in case they've tried mediation, or if they are interested in mediating. At AAA, we do have a master mediator panel, which in all regions. So whenever we initiate a case, which means that, when a case is filed and it would come to me, I would send a letter to both sides saying that we acknowledge the receipt of the case and set up an administrative call. We also send mediation resources, just so parties are aware that this is a resource available, and if they want to try mediation. And oftentimes, when we have this administrative call, parties are not aware of mediation. Sometimes they do have a clause in their contract and they are like, we've tried mediation, not interested at all. Both sides have to agree to mediation. So that happens too. But sometimes parties are like, oh, we didn't even know that, that's an option. And hence we at AAA, we send these resources, and we do see sometimes there is mediation prior to arbitration, and sometimes there's mediation in parallel to arbitration, which means that we have a mediation and arbitration going on simultaneously, and a mediator is appointed, and the mediator would resolve some issues and the others would be resolved through arbitration. We also tell parties, if you're not interested in mediation right now, you can always come back and let us know. So absolutely, we provide all sorts of options, and we are seeing more and more step mediation clauses are being incorporated in clients because it saves money for the clients.
you can explore that with Clause Builder and see what options.
Yes.
And so I guess in closing, I just want to point out that Clause Builder, it offers a template, but it offers much more than that. It offers an intelligent framework to analyze potential dispute scenarios, recommend specific language, and help create the most robust process for your clients. It's an intelligent partner in your drafting process. that allows for resiliency and providing a clear and efficient pathway to dispute resolution. And I think we're at our time. If you have any questions, please feel free to reach out to either one of us. Also, if you're interested in getting involved with the EASL, New York State Bar Association's section, EASL section, our ADR committee that I co-chair, please reach out to me through the New York State Bar Association or my email address in the chat. And I thank Monsi for participating and sharing with us today and the demo, and to Charmin and Gina for being our administrators on this call. And thank you very much, everybody, for attending. And I look forward to hearing from any of you who have further thoughts or comments or questions, as I'm sure Monsi does as well.
Absolutely, I'm here to answer any questions. I did drop in my email, and please provide us feedback on Clause Builder, and it's always great to partner with Kyle Beth and Easel. And thank you, Nisba, for helping us host this today. Have a great day, everyone.
Thank you, everybody. Have a good afternoon. Bye-bye. Charmin, are we still live?
Jeez. Thank you. So this concludes today's seminar. Thanks for our faculty for your time and insight this afternoon. For those of you who are still online, please take a moment to fill out the evaluation in your learning dashboard. Your feedback is important and valuable to us. Thank you for choosing New York State Bar Association programs.